there are various defense strategies when it comes to conspiracy cases. Attacking the knowing and willful elements of the conspiracy are always going to be at the forefront. Did your client knowingly and willfully join a conspiracy? Did they engage in a criminal partnership as opposed to them believing that they joined into a legitimate business that turned out to be criminal? The agreement itself, the partnership itself, and whether there is evidence of that is at the forefront. Now, the government does not have to show and the statute says this, and the instructions on the law that a jury reads says this. They don't have to see a shaking of hands. They don't have to see a text message that says, hey, let's get together and violate the law. We don't see that very often. They're allowed to prove the knowledge element of conspiracy when it comes to, did this person have the actual intent to knowingly and willfully join, through circumstantial evidence or through context. So that is usually the element that we are focused on very often. The other way I would say that's probably most common among different ways is attacking the cooperating witnesses, attacking the credibility of the cooperating witnesses. So, in a conspiracy case, because you so often have cooperators, there are ways to impeach them, there are ways to attack their credibility. There are laws and instructions that say to a jury, if a matter goes to trial, a conspiracy case, they are allowed to consider, and they actually, must consider that someone who took a plea deal, in order to testify, you can look at them, ladies and gentlemen of the jury, with less credibility automatically. Someone who is cooperating, someone who received immunity, they automatically lose credibility and are actually instructed to do so, and for this to happen by the judge. So attacking the credibility of the cooperators and attacking the knowing and willful partnership itself, I would say, are the two main defenses we have in a conspiracy case.